William Large will be speaking against the bill.
Okay. Thank you, Mr. Chairman. My name is William Large. I'm the president of the Florida Justice Reform Institute. We are opposed to this bill. And just to clarify some issues that have been discussed, I want to make two concessions real quick. And I want everyone to understand the difference between pre-judgment interest and post-judgment interest. In Florida, in personal injury cases, we have interest accruing for post-judgment awards. The finders of fact, the 6 jurors, have looked at the fact pattern and said the defendant owes money. The judge signs that order, it's stamped in with the clerk. From that point on, you owe interest. Right now the interest rate is 4.75% per year. If you want to appeal that judgment, that's what you're going to pay. We're talking about pre-judgment interest. What is so different in a personal injury case, and why I need to distinguish the cases Mr. Posgay mentioned, is that pre-judgment interest in Florida occurs when you have a liquidated damages of an exact amount, where the monetary damages are easily calculated. The Alvarado case that Senator Bradley talked about and was in the staff analysis, in that particular case, that issue had to do with the defendant actually paid the money out of pocket. It wasn't speculative in nature. Unfortunately, personal injury litigation is speculative in nature. That is what the finder of fact, the jury, is arguing about. So, for example, a typical personal injury case, you would look at the following issues. Medical necessity of procedures. Yes, the person slipped and fell. Yes, the person was injured. Did they need to see a doctor 1 time, 10 times, 20 times, 50 times? Another factor regarding economic damages in a personal injury case is lost wages. The person, did they lose per year $100,000 in lost wages, $250,000, $1 million a year in lost wages? That's the issue that the finder of fact has to grapple with. Another issue with respect to past economic medicals is, what are the costs of those medicals? The letter of protection might have a face value of $1,000, but medical pricing in the geographic area is $250. All those issues need to be grappled by the jury in terms of coming up with an award, in addition to looking at the liability picture. Because of that, those damages are speculative in nature, and we don't want to have an interest rate associated with them. We want to give the defendant the right to defend that case without having to pay an additional, right now currently the interest rate would be 4.75% on the speculative nature of all those issues. I do want to also address the issue of attorney's fees. With respect to an offer of judgment, for example, Mr. Posgay is probably from the premier Jacksonville firm. If his firm files an offer of judgment, it will strike fear in the defendants, because if they are offering $1 million and they hit above that, they get $1,251,000, you are paying their attorney's fees. So later, there may be an attorney's fee hearing, but if you started to pay the attorney's fee interest rate award from the time that the attorney was retained, that's yet another cost driver. So personal injury litigation is speculative, lost wages, medical costs, medical necessity. It's not fair to defendants to put an award on that before there's a judgment. Post-judgment interest works. Post-judgment interest is fair. Pre-judgment interest in personal injury cases is unfair, and we'd be opposed to this bill.
Okay. Question to Senator Soto. Question to Mr. Large.
Thank you, Mr. Chairman. Is there anything uniquely speculative about personal injury versus like lost profits or business cases as far as a pre-judgment analysis?
Yes. I mean, if you're dealing with property damage and you have someone, you lose a piece of property, that's more easily tangible, it's easily calculated, versus a personal injury litigation of how many times do I need to see a doctor, what are my lost wages, what are the costs of the medicals. It's very different in nature.
Follow-up, Senator Soto? Okay, anybody else?
Okay, thank you.
Senator Ring, I'm sorry. Senator Ring has a question for you, Mr. Large.
So, is it accurate that if we pass this legislation, that Florida basically moves in line with where most of the country is? And if that's the case, have you seen it detrimental in the rest of the country? Because what I'm seeing here is, and tell me if it's inaccurate, is there 33 states have already moved forward with this?
Mr. Large?
Senator Ring, my research reveals 10 states that very clearly have prejudgment interest in statute. The staff analysis notes the 33 cases. I have to concede that. But what is occurring in virtually all states, if you look at it closely, is the tangible nature of it. And just because the other states are doing it, I don't believe it's a good idea. The courts of Florida have grappled with prejudgment versus post-judgment interest, and the issue there is let the defendant have their day in court to argue this. This is another leverage issue that defendants would have to be grappling with if they had to pay the prejudgment interest rate, which, by the way, right now is 4.75%. If the Federal Reserve continues to raise interest rates over time, could be even higher and higher. They were very high in the early 1980s, for example.
Well, I mean, who do you think waiting helps? Does it help the plaintiff or does it help the defendant? I mean, you know, who has more leverage? Obviously, the longer you wait.
The person who has to eventually pay the check, that person is weighing the potential leverage of the verdict, the offer of judgment, and now potentially interest rates, and that decision whether or not to pay the claim at mediation or settle the claim earlier. So the person who doesn't have the assets and gets to add now an additional cost gets the leverage against the person who has the assets. So those factors are there. The interest rate calculation here would prevent defendants from getting their day in court.
Okay, I want to be clear. What you just said is that the plaintiff, the person, has more leverage than the defendant. The defendant can wait it out a lot longer. I mean, you don't have to answer the question. I want to be just clear with what you just said, that the defendant has less leverage.
Well, sir, in any case, you have got to look at all the costs associated with paying a potential verdict or settlement. And those costs are all the economic awards, the interests, and everything else. And the issue isn't necessarily one of leverage, but the issue is one of what potentially you would have to pay in the future. And if you have prejudgment interest on top of that, that's a factor that you have to assess the value of the claim.
You don't have to answer. So let me just
Senator Ray.
one statement.
Statement,
You know,
Mr.
with that, this is all about leverage. And I think to indicate that it's not about leverage is being highly disingenuous.
Okay, thank you, Mr. Large. We're now going to hear